item of business is a debate on motion 20452 in the name of Marie Todd on the Disclosure Scotland Bill at stage 1. Can I invite members who wish to speak in the debate to press the request to speak buttons now, and I call on Marie Todd to speak to and move the motion. Minister, please.
Thank you, Presiding Officer. I am pleased to open the debate on the general principles of the Disclosure Scotland Bill. I wish to start by thanking everyone who has contributed to developing the bill so far. This bill is ambitious, touching upon complex and diverse matters. Input from private individuals, employers, advocates, regulators and many others has been absolutely invaluable to understanding what they need and what we can achieve with this bill. We have been listening since its introduction, listening to the evidence given to committee and engaging with over 700 individuals, including children and young people, through events held by Disclosure Scotland and Volunteer Scotland. We have worked hard throughout to discover how we can make state disclosure work better for everyone. I know that these proposals are a significant change. To get all the benefits of the changes, we'll need to maintain that engagement as we work towards implementation. I believe the evidence given to the committee reflects the level of constructive cross-sector engagement that has already been towards getting this legislation right. I also wish to thank the members of the Education and Skills Committee for their considered approach to stage 1. In particular, I welcome the committee's support for the general principles of the bill. I have taken time to consider their recommendations, and I am just as committed as they have been in providing a constructive response. The Scottish Government has worked in recent years to improve the justice, rehabilitation and disclosure systems. The Disclosure Bill is the next step to ensure we can continue to support safeguarding Scotland's most vulnerable people, whilst also recognising the right of people to move on from their past behaviour. It is with this context that I consider the committee's recommendations. The bill introduces new and reformed processes to allow certain information that could be disclosed to be fairly assessed. The current system provides only limited opportunity for people to challenge what is included on their disclosure. The reforms will ensure that people can interact with the disclosure process and expect it to take account of their circumstances. This does not mean that we will stop disclosing information relevant to safeguarding. It simply means that our disclosure system will be better able to take into account the individual circumstances surrounding offending behaviour. This is particularly important when considering childhood offending. The Disclosure Bill will afford new protections to people who, as children, came into contact with the justice and hearing systems. The provisions allow the full context of childhood behaviour to be considered before a decision is made about whether to disclose such information to a third party. I welcome the committee's recognition of the particular needs of care-experienced people and our duty to listen carefully to their voices in developing policy. In evidence, we heard from Robert Dorian, a care-experienced young person who described how a childhood conviction for which he was admonished followed him through his education and limited his opportunities as a young adult. That must change. It is vital that those who have experienced adversities in their childhood are not further held back as they try to move on as adults. Certainly.
Daniel Johnson.
Minister for giving me, and I think she makes the point very well about how such incidents can affect future chances. But one concern was raised was whether or not sufficient consideration to other relevant information and whether or not those same behaviours might be disclosed as other relevant information, even though they would not be disclosed as childhood offences. I'm just wondering what consideration had been given to those concerns.
Minister.
Certainly, we've given a great deal of consideration to the committee's concerns around the disclosure of other relevant information. I can assure you that we're not planning to change the process of disclosure, how we make those decisions. What we are planning to do is communicate better how those decisions are made. We also seek to reform the process by which some spent convictions can be removed from a higher level disclosure. There are many sensitive roles where it's accepted and proportionate that convictions that would otherwise be forgotten still get disclosed. This allows employers to properly consider past conduct before putting someone into a position of responsibility. The Supreme Court has accepted it is appropriate that we can set out clear thresholds regarding offence type and severity. Having lists and criteria against which disclosure happens enables a proportionate and foreseeable system which can be delivered within reasonable operational limits. Currently, removing convictions requires a summary application to the sheriff. We've been told that this process is time-consuming, expensive and intimidating for potential applicants. The bill will change this so that the new first step will be a simple review request to Disclosure Scotland. If Disclosure Scotland then decides the information should be included, the applicant can opt for independent review. I recognise and accept the committee's position that allowing subsequent reviews of the same information at a later date would enhance proportionality. This means that a state decision to include conviction could later be changed as time passes or circumstances change, and I will bring forward a Stage 2 amendment for consideration. Now, as I said, I know that there have been concerns raised surrounding other relevant information, or ORI, within the bill. It's important to remember that the provision of ORI is not something new which is being introduced by the Disclosure Bill. Inquiries following the Dunblane massacre in 1996 and the Soham murders in 2002 highlighted that we needed to better manage information about individuals for whom there are valid safeguarding concerns. Certainly.
Liz Smith.
I'm very grateful, and I entirely agree with the Minister about the sensitivities over this. I think she's absolutely right what she's just said. One of the issues that was put to us is that sometimes you end up in a situation where the person who has information disclosed about them is not able to see the full amount of that information with the person who is reviewing that information. Does the Minister have any concerns about that?
Minister.
So the bill that we have put forward proposes that an individual who is requesting a disclosure a disclosure certificate will see the information that is going to be disclosed about them before the employer does. They will then have the opportunity to have that information reviewed by the independent reviewer, and the independent reviewer, it is planned, will give some feedback on the decision so that the person who is applying for disclosure will be significantly better informed under the new system than they were under the old system. ORI, as I said, has a vital role in safeguarding, and its continuance is necessary for public protection. I am confident that Police Scotland and other UK police forces exercise utmost rigour before deciding to include ORI. The main changes that we're making are to mirror the arrangements that exist in the rest of the UK. That means, as I've said, that people have the opportunity to dispute its inclusion before a potential employer receives it, and will have the right to review from the independent reviewer. Statutory guidance, as I said to Daniel Johnson, on deciding to include ORI will also be issued to the Chief Constable. These changes will ensure what information may be included is more foreseeable, diminishing the capability to share, without diminishing the capability to share relevant information. The committee has recommended that we include in the bill the guiding principles which should apply to all decision making. Though the existing parameters have a very strong basis in the relevant case law, I accept the calls for including more detail in the bill to assist with foreseeability and clarity. I'm carefully considering the recommendations on how best to include these principles. It is important that these do not compromise the flexible approach necessary to fully consider each individual's circumstances. I also recognise the concerns around how the Disclosure Bill will interact with the rules on self-disclosure in relation to childhood conviction. There are a number of challenges in ensuring that we get the balance right between safeguarding and proportionality, and at Stage 2 I'll bring forward amendments to ensure that no one will have to self-disclose a childhood conviction that would not be disclosed by the state. The Scottish Government's experience of operating the PVG scheme since its introduction has highlighted the challenges of identifying eligibility for the PVG scheme. The last 8 years have demonstrated that regulated work is poorly understood and overly complex. The bill seeks to address these concerns. Discussions with stakeholders on the definition of regulated work indicated that many felt this needed to be much clearer. It was also evident that to ensure a robust PVG system, the definition of regulated work needed to go further and to include those who have the ability to exercise power or influence over vulnerable groups. We've consulted on what day-to-day activities result in power or influence over vulnerable groups. These activities and the definition of contact are set out at Schedule 3 and 4 of the bill. Many stakeholders have told us the new schedules offer more clarity. However, I am conscious that clear and accessible guidance will be required to fully support them. We are committed to working with stakeholders, including smaller businesses and voluntary organisations, in developing this guidance. I've also noticed the concern raised by Scottish Women's Aid and the committee regarding the proposed change to the definition of protected adult. The intention was to move away from the current lengthy and complex definition to focus on the range of issues affecting a person's well-being, capabilities and capacity. I recognise that in doing so, some of the nuance in relation to those who are vulnerable due to their circumstances may have been lost. And I thank Scottish Women's Aid for highlighting this, and I will bring forward a Stage 2 amendment to ensure such groups remain within scope. The bill is founded on extensive and ongoing engagement with a broad range of stakeholders. We have listened very carefully to diverse voices from across Scotland at each stage of developing the bill and look forward to continuing this approach as we progress. If there is one message that I ask members to take into this afternoon's debate, it is that I am listening and I will consider carefully what more might need to be done. I acknowledge that we may have different views on the best way to progress on some aspects of this innovative bill, and I've welcomed the constructive discussion that we've had so far. I commit to work with stakeholders and with members on the committee and in the wider Parliament to ensure that we are working together to get this right for our communities, for vulnerable groups and for businesses and charities in Scotland. I look forward to the debate this afternoon and to hearing more of the views of members across the chamber, and I'm pleased to move the motion.
Thank you very much. I now call on Claire Adamson to speak on behalf of the Education and Skills Committee. Convener, please.
Thank you very much, Presiding Officer. Can I take this opportunity as Convener of the Education and Skills Committee to thank the committee members and the Clarking team for their support during the Stage 1 deliberations of the Disclosure Scotland Bill. This bill has the opportunity to be transformative for some people who find themselves in the disclosure system. And I was very pleased to hear the Minister mention Robert Dorian. And I think it's very important that the Chamber understand fully what impact this may have to young people like Robert. And I would like to quote him and say, "I have an experience of disclosure process. I accrued an admonishment when I was 16. I have a very real interest in the bill because it can affect change. There is a lot of conversation to be had about the intention behind the bill. My journey has been made more difficult than it had to be. Throughout my time, I have lost out on lucrative jobs, been passed over for consideration, and have had to have more than one awkward conversation. That could and should have been avoided. Had the recommendations in the bill been enacted years ago, I might be in a different position from the one that I'm in today." And, Presiding Officer, I think those words just highlight how vital it is that this bill is fit for purpose and works for everybody that interacts with the disclosure scheme. That being said, Presiding Officer, it is a complex and indeed technical bill that we have before us. As the convener of the committee that was charged with scrutinising the bill at Stage 1, I believe that the evidence we heard provides us with encouragement about the positive aspects of the bill, but also highlighted some areas where the committee believe further work is needed to ensure the bill has optimal impact, and I will try to cover it in my speech today. Before doing so, can I also thank all of those who gave evidence to the committee, whether that was part of our focus groups on the bill, or providing written submissions, or indeed attending committee to give oral testimony at evidence sessions. And I also take this opportunity, as we did in our report, to acknowledge the extensive work that the government has done in engagement before drafting the bill that is before us today. We heard from a wide range of witnesses, including many smaller voluntary groups and charities which interact regularly with the disclosure scheme. and the lived experience of those giving evidence were particularly helpful in illuminating the committee's understanding of the potential practical challenges and opportunities within the bill as it is currently drafted. I would also like to thank the bill team from Disclosure Scotland, whose detailed pre-introduction consultation and constructive cooperation with the committee throughout stage 1 was very much appreciated, and welcome the Scottish Government's constructive and detailed response to our stage 1 report, which was received on Tuesday. I will focus my comments today on some of the recommendations included in our stage 1 report. I will not have time to pick up on everything from the stage 1 report, but hopefully this will give colleagues some food for thought ahead of stage 2 and where we expect to consider amendments on a range of provisions within the bill. I mentioned earlier that some would view the bill as complex and technical, and this is certainly the case with regards to its interaction with other pieces of legislation. We were very concerned by some of the discrepancies between this bill as currently drafted as it relates to acts recently passed by the Parliament, such as the Age of Criminal Responsibility Act and the Management of Offenders Act. In our report, we have asked the Scottish Government to address these discrepancies at stage 2, and I note the Government is committed to doing so in its response to our stage 1 report. I also welcome the Scottish Government's reassurance that the bill was drafted with the UNCRC principles in mind, which was another concern raised by the committee. Another challenge addressed by the committee was the two-part test in relation to level 2 disclosures. The two-part test is whether the information ought to be included in the disclosure or whether it is relevant for the purpose of disclosure. We heard from a number of witnesses, including the Law Society of Scotland, who felt that further clarity was needed on the operation of these tests, particularly with regard to childhood convictions and the disclosure of other relevant information. And I know Mr. Daniel has Mr. Johnson, Presiding Officer, has already raised this issue in the course of the debate this afternoon. In our report, we welcomed the Scottish Government's commitment to develop guidance in collaboration with stakeholders, but also recommended that the Scottish Government consider the suggestion from the Law Society of Scotland that a set of guiding principles or criteria could be included within the bill. I am encouraged that the Scottish Government has stated in its response to our report that an appropriate stage 2 amendment will be brought forward with this regard. As members can infer from the testimony of Robert Dorian, the bill seeks to reform how offences committed by young people aged between 12 and 17 years old are disclosed. The policy memorandum of the bill states that one of the policy goals of the bill is to recognise adolescence as a unique phase of life by ending the automatic disclosure of convictions accrued while aged 12 to 17 and introducing an assessment by Disclosure Scotland acting on behalf of ministers as to whether convictions ought to be disclosed. The goal was welcomed by a number of witnesses, but I want to focus in particular on the people like Robert who are care experienced, as Who Cares Scotland told the committee, although those who have been in care make up an estimated 0.5% of the population, they make up 33% of Scotland's youth offender population and 31% of Scottish adult prison populations, making them much more likely to be impacted by decisions taken about the disclosure scheme. I spoke earlier about the potential to provide the context for offences. Our report therefore stated that more could be done to provide opportunities for any information relating to childhood offences included in a disclosure to be set in context. This is particularly important for care experienced people, given the disproportionate level of engagement with the justice system, and we hope that this is at the forefront of everybody's mind as the bill progresses. Of course, the disclosure scheme is also about enabling individuals to take on roles where they could work with vulnerable groups. One concern the committee holds is over the current proposal to prevent under-16s from obtaining PVG scheme membership. And Sarah Latto of the Scottish Volunteering Forum told us, given that there is also the proposal to make being a PVG member mandatory for doing regulated roles, a lot of organisations would interpret this as meaning that people under the age of 16 would no longer be able to do any voluntary work with vulnerable groups. We think that that would be a real shame, and that it would reflect current circumstances and roles that young volunteers fulfil. So in our report, we have recommended that the Scottish Government conducts a review of this change to measure any negative impact on volunteering rates among young people, as well as developing guidance and otherwise supporting organisations to continue to offer volunteering opportunities to those under the age of 16. Finally, Presiding Officer, the committee considers the financial memorandum of the bill, in particular the fee structure for those applying for disclosure products. We recommended the waiving of fees for volunteers obtaining any disclosure product, not just PVG scheme membership. The Scottish Government has committed to a wide-ranging consultation on fees, which I'm sure we will all follow with interest as the bill progresses. It would be remiss of me not to mention the recent Section 22 report on Disclosure Scotland's IT system, and the committee has exchanged letters with the bill team to obtain assurances from that the findings of the report do not affect the financial memorandum for the bill. There are other areas considered by the committee which I'm sure will be picked up elsewhere in the debate this afternoon, such as the use of other relevant information and the change from regulated work to regulated roles. But I am running out of time rapidly. And
No, you can have a little bit extra if you need it. I saw you looking anxiously at the clock with time in hand.
Okay, I will conclude by reiterating that the committee supports the general principle of the bill. However, we do believe that there are a number of areas within the bill which will require further clarification and consideration at stage 2, and to ensure that the bill delivers on its full aims, and that we look forward to considering the amendments at stage 2 to strengthen this vital component of our protection of vulnerable groups. So in closing, Presiding Officer, I just want to reiterate again my thanks to the many organisations who have engaged with both the government consultation and the committee in this respect, and that have brought us to this position with a stage 1 report that is robust, and we look forward to hearing the debate this afternoon and hearing how we might progress at stage 2. Thank you.
Thank you very much. Yes, I can say to members there's a little time in hand, so I'm not being too constrictive with timing, well, within limits. I call on Liz Smith over the Conservatives. Ms Smith, please.
Thank you, Deputy Presiding Officer. Can I immediately put on the record that I am the holder of a current PVG certificate? I think since the bill was introduced in this Parliament on the 12th of June of last year, I think it's very clear that the general principles of the bill are warmly welcomed. I can't really see any concerns amongst any stakeholders that this bill shouldn't be happening. In fact, I think it's a very bold move by the Scottish Government to try to improve, to work through the complexities of this area and a lot of the sensitivities that go with it. So I think, generally speaking, I think this is a good move. That said, I think the more we look into this, the more the complexities actually appear. And I'm not convinced yet that we have a way through some of what I think are very considerable problems. I'll come to these in just a minute. But I think the general approach of simplicity, I think that is warmly welcome. I think the move away from the current 4 different classifications, I think that is warmly welcomed by all the stakeholders. I think the Scottish Government is quite right to try to address that problem. I think we warmly welcome the progress towards a much better digital system and one that obviously is in theory a bit more like the environment, the non-paper based environment in which we all live today. And I think there are also a lot of good things. The Minister mentioned the recognition about adolescence being a particular phase in somebody's life. I think we can all agree with that. But I think it's very important that we look at the common sense that can be applied to the judgments. Should somebody have fallen foul in the past, either through the justice system or through the hearing system, I think that's absolutely appropriate. Can I deal, Minister, with some of the fundamental problems as they stand just now? Not problems, I don't see this as a party political issue whatsoever, but addressing some of the practical discrepancies which have been raised consistently by stakeholders throughout the several months that we've been looking at the evidence, whether that's the Law Society of Scotland, Children in Scotland, and Recruit with Conviction, to name just a few. If we allow, and I believe we should allow, this Stage 1 bill to proceed. It's the Scottish Conservatives' recommendation that some fundamental changes are required to avoid further complicating, which I think is an already complicated landscape on what is often a very sensitive issue. And I think the committee report captures these concerns, and we certainly welcome the general thrust of the comments that Claire Adamson has just spoken about. So what are these concerns? Firstly, whilst I think a central theme of this bill is very much one of simplicity, the Scottish Government really does need to state clearly how the Disclosure Scotland Bill will fit in with other legislation and other instruments. Actually, it's not just about legislation, but the other instruments. For example, as this has been highlighted, I think, several times by various stakeholders, the Management of Offenders Scotland Act in 2018 directs self-disclosure, and the provision for under-18s that are based on the date of conviction. This bill, however, contains provisions for state disclosure and includes provisions for a date of offence. And I think members will see immediately how this might have some unintended consequences and some legislative conflict. So I think it's important that much greater thought is given to the necessary coherence within different aspects of legislation. Of course.
Marie Todd.
In order to respond to that particular point, since the Rehabilitation of Offenders Act was developed, the period of disclosure has always been set from the date of conviction and based on the disposals upon conviction. That's the most straightforward approach to take. In the period between offence and conviction, there is not anything to protect an individual from because they are not yet carrying the status of a person with a conviction. We decided to take a different approach following the model in the Age of Criminal Responsibility Act. Doing that ensures that we deliver on our commitment to treat childhood offending differently from adult offending behaviour. So in this bill, like the Age of Criminal Responsibility Act, we're taking the date of offence. The presumption provided for it, Section 41 of the bill, is there to help deal with the borderline cases where the behaviour was committed under the age of 18 and the conviction occurred after the individual had turned 18. So I hope that reassures you that we have considered that complexity and I think we have taken the appropriate choices.
That was a long intervention. I can give you extra time.
That's all right. No, that's a welcome clarification, and I fully understand the rationale behind what the Minister has just said, and that is encouraging that you have considered this. Nonetheless, I think when it comes to the language that is used in legislation and the language that is used in different instruments across this Parliament, we know what happens when there is a discrepancy and there's a different interpretation that is put upon these different things. And I think it would be helpful if within the guidance that we can have some clarity on that point. And I think groups like the Professional Standards Authority, for example, I think they have, they're responsible for the accredited registers programme when it accredits the voluntary registers of practitioners who are not regulated by law. They too are making the point about some of that coherence, particularly when it comes to groups that may be volunteers rather than under a particular professional code of conduct. I think there are some issues there, particularly if we're wanting to encourage more volunteers to come into the process. So I think this is an area that we definitely need to look at in stage 2. I think the government's also acknowledged, quite right and properly, that there are issues about the coherence. It is a difficult situation because this bill falls in between different portfolios. And again, this Parliament has often been challenged on that situation, and we know what happens sometimes if we pass bad legislation, that we end up in a situation where we're having to undo a lot of good things. So I think it is worthwhile spending a lot of time at this stage and getting stage 2 right so that there is a consistency. And on that note, Deputy Presiding Officer, I think there is perhaps an issue about the timescale for this. I think that, as I understand it, stage 2 is just a couple of weeks away, and that's actually quite a short time just to deal with some of the issues. Perhaps the Minister might like to think about that. Secondly, I think, can I just turn to what I think is actually the most difficult issue, and that's one of legal as opposed to legislative nature. At the committee session on the 20th of November, I asked the Minister about the nature of the two disclosure tests, the relevant and then the ought to be disclosed. And I asked this because as yet I don't think there's enough clarity regarding the criteria that are to be used by decision makers. And I know other members, I think Daniel Johnson's one of them, that shares this concern. In line with what the Law Society of Scotland and the Howard League have advised, it's surely essential that there is very clear guidance, firmly rooted in the law, and the foreseeability of outcomes. Members know only too well what happens when that is not the case in this Parliament. And as things stand just now, the decision-making provisions within this bill remain, I think, really quite complex. I think there's a lot of issues there just to tie up before we move on with stage 2. Deputy President, can I just ask how much longer I have? Just a minute.
I can quite happily give you another minute or so.
Fine, 'cause I think these are important points. Can I turn a little bit to the issue of volunteering, which I know my colleague Brian Whittle will expand upon. But I think at the end of the day, the purpose of this bill must be about the trust in the system and about ensuring that when a parent brings a youngster along to Scouts or to a sports group or to Duke of Edinburgh, whatever it might be, there is absolute trust, not just in the integrity and the probity of the person who's in charge of the group who's going to be looking after them, but in the system that backs them up. I think that is absolutely crucial, because we've got to ensure that we have a lot of volunteers. The communities depend on the strength of these volunteers. And therefore, I think this argument about what is defined as regulated work as opposed to regulated roles, I think that's a very important consideration. I'm thinking about some stage 2 amendments that might just clarify some of that. Can I just finish my comments on the fact that I think it is essential, and sometimes this happens in Parliament, when we're presented with what looks like, in theory, a very straightforward issue, but in practice it actually turns out to be incredibly difficult. And I think this is one of these bills, and I think the Minister thinks it's one of these bills as well. And I think we just have to try to ensure that we are united as a Parliament to try to get across some of these practical difficulties. I think the committee has made a good start on that. I think the Minister's comments reflect that. But I don't think this is going to be an easy bill. I think it's quite a challenging situation, so I'll leave it there. Thank you.
Thank you. I call Ian Gray for around 7 minutes, please.
Thank you very much, Presiding Officer. I'm very pleased to join in the welcome for this legislation to the Chamber, following the committee report on the bill, and my Labour colleagues and I will, as with speakers from other sides of the Chamber, will support the general principles behind the bill this evening. I think it is worth spending a little time on the context of this legislation. Last year, we celebrated the 20th anniversary of this Parliament, and there was a fair bit of debate around what was the biggest or the boldest or the most controversial legislation that we have passed. But actually, of course, a lot of what we have done has been consensual, passed quietly, but with great care. And a lot of it has been exactly about protecting people, especially children and the vulnerable. Although Liz Smith is right, that can still be complex, even though it is consensual. Indeed, the very first Non-Emergency Act the Scottish Parliament ever passed did just that, the Adults with Incapacity Act, which I had the privilege of taking through Parliament with the then Justice Minister, Jim Wallace. Happy days indeed. Legislation which took incapacity legislation, some of which was centuries old, and replaced it with what was at the time was the most modern comparable legislation anywhere in Europe, exactly designed to protect those rendered vulnerable by disability, illness or age. And it was notable for two things. Firstly, it created a system unique to Scotland and Scottish needs. And secondly, although it's not often acknowledged in the commemorations of the Parliament's work, it has actually in the intervening years been used, I think, by almost every family in the country. Sometimes the quietest legislation is indeed the most effective. And disclosure is a bit like that, I think. Over the years, we've taken the legislation we inherited, the Rehabilitation of Offenders Act, 1974, the Police Act, 1997, and built on that through the creation of Disclosure Scotland, the Protection of Vulnerable Group Act, 2007, and various amendments since then to ensure compliance with human rights. We've worked as a Parliament, quietly over time, without fanfare, to ensure Scotland has the right processes to protect Scotland's people. And it is simply, I think, the next stage in this which brings us here today. So like the Incapacity Act, these quiet legislative waters do run deep. The committee heard evidence from Disclosure Scotland that the PVG scheme now has 1.2 million members, 1 in 5 of Scotland's population. So, especially for those of the committee, any time we feel that this is a bit dry and technical and complex, we need to remind ourselves just how important this system is to the protection of the vulnerable in their contact with adults, both professionally and in a voluntary capacity, through every imaginable aspect of life and society. And as for the consequences of getting this wrong and the system failing, we need only look across this city to the historic child abuse inquiry to hear exactly what happens when we do fail to protect children and other vulnerable groups, and just how much hurt and suffering ensues. Not bad things which happened somewhere else, somewhere dangerous, but things which happened right here in Scotland and in the very places which were supposed to be places of safety and security. A constant reminder that this legislation is so important to get right then. No wonder then that the legislation to modernise child protection laws and to strengthen protections for vulnerable adults has been indeed welcomed, as many have said already, by a broad range of organisations who have responded to the consultations and provided evidence to the committee. Now, the committee, as the convener told us, supported the general principles of the bill, but did say that there are a number of areas within the bill which require further clarification and consideration. Crucially, is this question, of course, of how the bill does interact with other legislation, particularly some recently passed by the Parliament, the Management of Offenders Bill, the Age of Criminal Responsibility Bill, and we still await answers in detail to how we do that, although I think the Minister has made a welcome commitment to bring forward amendments at stage 2. We, for our part, will at stage 2 seek a commitment from the Minister to publish an analysis of the interactions with other legislation before the bill is actually enacted, on the assumption that it does pass into law. We believe ministers should also look again at the evidence provided to the committee to make sure that the right balance is reached between protecting vulnerable groups, providing information for appointments to sensitive roles, respecting individuals' rights to privacy, and allowing individuals to move on from offending behaviour. And sometimes the relationship between those things is indeed difficult. That's why we think, and my colleague Daniel Johnson will say more about this, that consideration should be given to greater clarity of the principles to be applied, indeed, on the face of the bill. And again, I welcome what we heard from the Minister earlier on, but clearly we have to see the detail of how she intends to try and deliver that. It is also important that the bill ensures that proposed changes are user-friendly for both organisations and individuals, and it is clear from the evidence we received that some work remains to be done. The disclosure system has to be easy to understand, particularly that relationship between regulated work and regulated roles, and that was indeed, as Liz Smith said, a clear theme in the evidence. In stage 2, I would also like to see us examine regulated roles further so that organisations such as Shared Lives, who support adult carers, be given the same parity with foster carers who care for children. So finally, Presiding Officer, next week we'll see the launch of the care review, and once this bill passes, as I'm sure that it will, we really would urge the Scottish Government also to review the impact of the legislation on those who are care experienced. We heard one case, the committee convener spoke about one piece of evidence that we received, but we did hear different pieces of evidence, different aspects of the legislation, and how they might have a particular and disproportionate impact on care experienced young people building their life and future. So all of this is just the detail of the next stage in 20 years of quietly but effectively improving the protection of vulnerable Scots, and we are sure that this bill will do that too, and so the principle is certainly one which we will support this evening.
Ross Greer for around 6 minutes, please.
Thank you, Presiding Officer. As a PVG scheme member myself, I've found this stage 1 process to be quite an interesting one. Robust and efficient safeguarding procedures are essential for the protection of vulnerable groups in our society, but those procedures will never be simple ones. There are balances that need to be struck, ensuring that vulnerable people are protected, whilst respecting the rights, particularly the right to privacy of those working with them to the greatest extent possible. And this is particularly the case when these are not two separate groups, where a person who is themselves considered vulnerable, perhaps by dint of their age, wishes to take on a role engaging with other vulnerable individuals. And that point in particular is one which has proven a consistent theme in the Education Committee's consideration of the Disclosure Bill, and it's one that I'll come back to in a few moments. The interaction of this bill with the wider agenda of restorative justice, particularly recently passed legislation, has proven complex, as Liz Smith in particular outlined. But it's neither just nor sustainable for everyone with a past offence to be branded for life, but we clearly need a system where those who present a risk are not permitted to work with vulnerable groups. And the aims of this bill are sound. They will have the unanimous support of Parliament. As a scheme member, I certainly welcome the bill's intention to strengthen and simplify the system. As an example, the proposal to introduce regulated roles should lead to clearer understanding of where PVG membership is required. There's certainly been confusion in the past over whether certain roles and certain work requires disclosure or not, so the examples associated with the bill are helpful. The reduction to 2 tiers of disclosure should also simplify the system and ensure that only those convictions where there's a genuine need for disclosure have to be revealed. As a sensitive area of law, it can be difficult to get the balance right, and this is where case law plays a particularly key role, and indeed this bill does seek to incorporate new provisions derived from recent case law from both the UK Supreme Court and the Court of Session here in Scotland. In scrutinising this bill, the Education Committee heard evidence from a range of stakeholders, including those working with vulnerable groups and those working with ex-offenders. Feedback from these organisations wasn't unanimous in its views on some specific proposals, such as setting a new minimum age of 16 for PVG scheme membership, but their contributions were extremely helpful and broadly showed support for the aims and principles of the bill. The range of specific concerns raised, though, was broad, and I would expect the Government to address these as appropriate, either at Stage 2 proceedings or during the implementation of the legislation once it's passed. One particular concern which I share and pursued throughout our evidence gathering is the proposal to remove under-16s from the PVG scheme. The rationale behind this proposal is that the very small number of under-16s barred from working with vulnerable groups should already be known to the system, and that it's disproportionate to have a few thousand under-16s continuously monitored as PVG scheme members. I accept that rationale, but in combination with the offence for engaging in restricted work without having gone through a disclosure process, this does create a slightly anomalous and potentially confusing situation where under-16s would be engaging in what would otherwise be considered restricted work, but by dint of their age, it essentially isn't. Now, I absolutely accept under-16s shouldn't be undertaking this kind of work unsupervised, and an adult with PVG membership should be present. But the concern here is with unintended consequences, namely that the participation of under-16s in volunteering will be depressed by a perception that their being ineligible for PVG membership means they are ineligible for the volunteering work itself. Organisations may adopt policy of requiring all workers and volunteers to be PVG members, as indeed would be implied by the law, without consideration for how this would affect volunteers who are under the age of 16. Now, there are, of course, other Disclosure Scotland products, but this is where communication is key. We're largely talking about small voluntary groups here, not professionals. In addition to this, I believe a vulnerability is being created whereby other and imperfect services like social work and the police are being relied upon to ensure that the very small number of under-16s who are at risk and are barred from engaging with vulnerable groups are prevented from doing so. The specific concern that I raised was in situations where one of these young people were to move between local authority areas, the scenario in which communication between public agencies engaging with them most commonly breaks down, even if just for a short period of time. I accept that the risk of this is very small, but there was a thoroughness about the previous system encompassing under-16s, which is potentially lost here. But it's fair to say that the committee struggled with these issues. We did not come to the conclusion that this proposal was inappropriate and needed to change. but the concerns raised were compelling enough to lead to the conclusion that we recommend the government reviews the participation of under-16s in voluntary work following an initial period of the operation of the new system. I'd appreciate a commitment from the Minister today that this review, a quite reasonable request, will take place. The other area that I've spent the most time on concerns the new powers for Disclosure Scotland themselves. A two-part test is introduced to be exercised by Disclosure Scotland in situations relating to Level 2 disclosures. There are a number of factors that are to be taken into account during Level 2 disclosure to determine whether or not it would be proportionate. However, the bill lacks a clear framework and guiding principles for these decisions, and it means that a substantial part of the new system, procedures that directly impact on the balance between safeguarding and privacy and rehabilitation, were not available for scrutiny at stage 1. I appreciate that the government is committed to working with stakeholders to develop a framework for decision-making, but I do think it's bad practice for Parliament to pass legislation where substantive supporting documents such as guidance has not been available for scrutiny alongside the bill. Sometimes this is necessary, but I fail to see why that's the case in this situation. An over-reliance on secondary legislation or non-statutory guidance means that Parliament simply doesn't have the same opportunity to ensure that legislation is fit for purpose. Given the time, Presiding Officer, I'll finish there by asking the Minister to provide some further clarity on the points raised by the committee's Stage 1 report, which I've repeated here, and to give the Greens support for the principles of the Disclosure Scotland Bill.
Call Beatrice Wishart for around 6 minutes, please.
Thank you, Deputy Presiding Officer. The process of disclosure rests on the ability to have both consistency and discretion so that the system is able to ensure both fairness and protection. I agree with what was said in a case against the Metropolitan Police, and I quote, "The proportionality of the disclosure will inevitably require balancing the rights of individuals with the potential risk to members of society. This balancing act is of the greatest public importance." Putting that into legislation is obviously a delicate and complex process. The Disclosure Bill is the first piece of legislation I've had the opportunity to scrutinise since being elected to this Parliament, so I'm glad to begin with such an important act. Simplification is clearly necessary. Having patchwork legislation makes life harder for practitioners and harder for the people who work and live under the system. The disclosure process is only useful if it is effective, and it's only effective if it can be understood. I would support what Scottish Women's Aid said, and that it's only welcome, and I quote, "where this allows the same or improved levels of disclosure, coverage and protection for vulnerable people and does not inadvertently create loopholes capable of exploitation." Evidence heard by committee about consistencies between this bill and others have been passed by the Scottish Government in the same session was therefore concerning. Debbie Nolan of the Centre of Youth and Criminal Justice noted in committee that if those three pieces of legislation are not fully aligned, we run the risk of the benefits not being realised. If the government cannot produce consistency across legislation produced in the same year, an expectation of consistent decision-making by practitioners is already undermined. I would also note the need to create a regime that is able to stand the test of time. Other parts of these reforms were passed last year under the Age of Criminal Responsibility Act. The government's response to new calls from the international human rights community and amendments from my party mean that the new age of criminal responsibility already lags behind international expectations. Social Work Scotland said, "It is critical that Scottish Government and its agencies have a coherent and comprehensive understanding of how all these parts piece together, with systems in place for managing risks, tensions and overlaps." So I'd be grateful for the Minister's understanding of how this would be ensured should this Parliament step up to the plate and raise the age of criminal responsibility in future. The relationship between employment and a criminal record is complicated, but the potential for rehabilitation that meaningful work can offer must be recognised. While a job in itself might not trigger desistance, the stability and responsibility that it creates may actively stop a person tending towards reoffending. Research conducted last year by Beth Weaver of the Scottish Centre for Crime and Justice Research and the University of Strathclyde found that Barriers to work engendered by attitudes towards people with convictions and disclosure of criminal histories may destabilise efforts to desist and cut off opportunities to sustain desistance, thus ironically undermining public protection. So an overly restrictive disclosure regime is therefore in nobody's interests. In a similar vein, I would be grateful for reassurance as to the safeguards that would be put in place to ensure that the new offence that will be created for those who fail to secure a PVG isn't used as a heavy-handed response to bad admin. 12 months in custody may be appropriate where there is a deliberate intention to circumvent the scheme to target vulnerable people, but I'm not convinced that this is a proportionate response to other circumstances to which might apply, for example, what Community Justice Scotland called a lapse in paperwork. There have already been reports of delays to PVG applications at Disclosure Scotland as a result of hiccups with the new ICT scheme. The Scottish Government has responded in part to concerns, but I would be grateful for some further reassurances about IT capacity in light of the 1.2 million people that may need to reapply for PVGs as the renewal system gets underway. Overall, and although I don't think this is quite ready yet, the bill has the potential to make genuine positive changes to the disclosure process, and I can confirm that Scottish Liberal Democrats support the principles in this bill. Thank you.
That concludes the opening speeches. We'll move on to the open debate. Speeches of around 6 minutes, please. I do have a little bit of time in hand for interventions. And I call Rona Mackay, followed by Brian Whittle.
Thank you, Presiding Officer. I'm happy to speak in this Stage 1 debate on the Disclosure Scotland Bill, a bill which I believe is very necessary to bring forward at this time. Perhaps the best way to explain why is to quote the purpose of the bill from the policy memorandum. It states the provisions of this bill will deliver a range of positive and proportionate reforms to the disclosure regime in Scotland, whilst also strengthening the barring service to maintain Scottish Government's ability to protect the most vulnerable in society. So in essence, the bill has been introduced to modernise and improve proportionality in the disclosure system. It aims to balance public protection with the right to move on from past offences. It's split into two parts. Part 1 creates the legislative framework for the new disclosure products for criminal history and other information, while Part 2 is concerned with amendments and insertions into the PVG Act, the protection of vulnerable groups. This is a somewhat complex bill, as we've heard, which will require amendments at Stage 2 to achieve its desired purpose of making the disclosure scheme less complex. The current legislation provides for 10 disclosure products that stakeholders find confusing, and it's mainly paper-based. So the new bill will contain proposals to allow ministers to offer stakeholders online services that are not possible under existing legislation, while at the same time recognising that online access will not work for everyone and alternatives will be offered. So the number of disclosure products will decrease, reducing confusion, and improved digital services will guide employers and applicants to the right level of disclosure. Crucially, as we've heard, the bill will give individuals greater control over their disclosure data. They will decide whether disclosure information will be released to a third party without eroding the vital safeguarding role of disclosure. This is especially important for childhood convictions when offences accrued while under the age of 18. They'll no longer be automatically disclosed and will be eligible for independent review, which, if successful, will allow the young person to move on without being hampered by a childhood offence. I think this was probably best illustrated by the quote from our witness to the committee, Robert Dorian, of Who Cares Scotland, mentioned by the Minister and quoted by the convener. As the convener, Liz Smith and Ian Gray and others have said, the committee was concerned about the impact and interaction of this bill and that of the recently passed Management of Offenders Bill and the Age of Criminal Responsibility, along with proposed future legislation incorporating the United Nations Convention on the Rights of the Child. The Government has noted this, and the Minister addressed this in a reply to Liz Smith and has said it will bring forward amendments at Stage 2 to remedy this. And I'm also pleased with the reassurance that it was drafted with regard to UNCRC. The committee welcomed the role of the independent reviewer, but was keen that support services were in place by the time of the bill coming into force, which the Government has agreed to. The Government has also agreed that draft guidelines for the two-part test must be provided, and training must be part of this and be widely consulted. We were also concerned that an unsuccessful review of a List A offence cannot be reviewed for the same purpose twice, which could result in a lifetime of disclosure for the individual. And there was some confusion about how the review processes would actually work and how individuals could engage with the process. And these are issues which I believe must be addressed. The Government has committed to considering a set of guiding principles in this regard, and the Minister has outlined the situation around reviews. On the issue of other relevant information, which was a big issue for the committee to try to understand, as mentioned by Daniel Johnson and Liz Smith, and there was confusion about who was actually responsible for this judgment and what criteria would be used. And the committee was concerned that this would not allow individuals to move on from past offending behaviour, particularly with childhood offending and for care experienced people, by allowing employers to access this information despite the conviction itself being withheld. So the Minister has outlined the sensitivity of this and again the situation that she plans to clear up the confusion around this. The ORI is a key aspect of the disclosure schemes and doesn't erode the power which can lead to barring under PVG or discrimination in employment. However, I think it's understood that Police Scotland and authorities must reflect very seriously when deciding to include ORI. The committee also supports the continuing existence of lists of offences, but some anomalies which will have to be addressed that are, for example, fraud and embezzlement appearing in different lists, and this was also highlighted in the Law Society's helpful briefing. Presiding Officer, changes to the PVG scheme is an important part of this bill. The committee supports mandatory membership and the move away from lifetime membership to a renewable 5-year membership. This means that those who no longer need the accreditation will not need monitoring, and it will reduce the administrative burden. And Ian Gray reminded us of just how important the PVG and how popular the PVG scheme is. As Liz Smith mentioned, there was a bit of uncertainty around regulated work and regulated roles, which has led to confusion about who should and shouldn't become a PVG member, and I hope this will be addressed. As Ross Greer said, this does happen under the existing scheme. And with regard to under-16s, which Ross Greer featured heavily in his speech, we did express concern that the proposal for non-registration could contribute to a decline in volunteering opportunities, depending on how people and companies interpret the legislation. So I take the points that Ross Greer made, and I'm sure the Government will address this. And the Government has said that the number of under-16s applying to join the existing scheme is low, and there is automatic listing for those with serious offending background. In conclusion, Presiding Officer, the strong message we got from witnesses was that the PVG scheme is only one of a number of monitoring and screening processes, and that safeguarding will always be top priority. So with some important amendments that will come forward at stage 2, the Disclosure Scotland Bill is a huge step forward in many areas, and I'm happy to support the general principles. Thank you.
Brian Whittle, followed by Alec Neil.
Thank you, Deputy Presiding Officer. And I will start by reminding the Chamber that I currently hold a PVG certificate primarily because I'm still actively coaching all age groups and vulnerable groups. And I'm pleased to have the opportunity to speak in this debate. And if I may, Deputy Presiding Officer, I want to use my time to focus on the volunteer sector. I think we'd all agree that every precaution must be put in place to ensure the safety of the young and the vulnerable. There are far too many high-profile cases, as Ian Gray highlighted, where the vulnerable have been let down, and we must do everything we possibly can to make sure every protection is in place. We know the lifelong impact of ACEs, and it's been well documented in this place. So the need for a robust PVG check is apparent. Having said that, I would also highlight there is a need for the volunteer sector to be accessible to those so minded. Volunteering is crucially important in so many areas, especially in enabling communities to access activities that tackle isolation and health and education and social interaction. You'll know, Deputy Presiding Officer, I have a real passion for this kind of preventative agenda, and that these kind of community activities have a central role to play in improving the health and well-being of our nation and reversing a worrying trend in the preventable health. Moreover, volunteering itself can have such a positive effect on the lives of the volunteers. So we need to ensure that opportunities exist and are accessible while ensuring the highest standards of protection are not compromised. And I want to just raise a specific issue here around a friend of mine who there was a vexatious allegation against him, which was proven to be unfounded eventually, but the impact on him as a coach and his charges was quite profound, and I recognise it's such a difficult situation to address, but we must. It's not a situation where you're innocent until proven guilty. In this particular situation, you are removed from that situation immediately an allegation is made. So how we tackle that, I think, is extremely difficult, but I would like to put forward a particular suggestion around, in situations like that, that the coach becomes supervised by another coach potentially to ensure that protection is still there. Now, I've just recently renewed my PVG certificate, and it wasn't exactly simple and seamless. It required the club and myself to fill out forms, submit them to the governing body, fill them in again and submit them when something went awry in the process, and then wait 6 weeks for clearance. It's just cumbersome. So I welcome, as Liz Smith had mentioned, the move towards a digital system which should allow for a much more user-friendly experience. When renewing a PVG certificate, all we're really being asked is, has anything changed since it was last issued? A digital communication and collaboration platform should enable that kind of access to that kind of data routinely. In fact, I think that kind of system should be much more effective in the ongoing monitoring of those already holding a PVG check and be swifter in raising potential breaches. So I look forward to seeing that kind of system implemented. I would also highlight that at one time I held 3 separate disclosure certificates for different organisations for basically working with the same sort of vulnerable groups. So surely there's no need for that kind of duplication, and perhaps the bill allows us to tidy up that situation. I think one of the caveats I wanted to highlight is that being PVG checked should not be invasive. It should be seen as an enabler and welcomed by all those who participate, including keeping parents satisfied that their children are being effectively supervised. On that point, I think Chamber will know of the ongoing Petitions Committee, as well as the work in the Health and Sport Committee investigation into regarding child welfare in sport. They have certainly highlighted issues that are now being addressed, it would seem. Hopefully the outcome of those investigations and actions will be positive. I think it's imperative that sports governing bodies implement the highest duty of care for their members, and the work these committees have done and continue to do demonstrates that there have been quite a variance in the duty of care across governing bodies, and I would be interested to hear from the Minister how the Scottish Government will ensure full compliance with this legislation and how that will be monitored on an ongoing basis. I was also interested in Liz Smith's points around PVG provision for former young offenders who have demonstrated a period of good behaviour. And it brought to mind the scheme in Kilmarnock Prison, where inmates were offered the chance to take their football and rugby coaching exams. In fact, I brought a parliamentary football and rugby team down there to play the inmates and the prison guards football and rugby, which we all survived. It was a great opportunity to highlight that they are still members of society, who, having served their due sentence for the crimes they committed, will be expected to reintegrate into society. It's clear to me that a coaching certificate allows that possibility of delivering a positive contribution to their community and their subsequent acceptance back into that community. Of course, without the prerequisite disclosure certificate, they won't be allowed to deliver that coaching. Now, I definitely see where the issues are here. I am a parent with all the same concerns as any other parent, perceived or otherwise. But if we are to create the opportunity for those who have fallen foul of the law, we need to consider how these skills learned during their sentence can be utilised in the community. And again, perhaps it's working in partnership with other coaches and starting with the least vulnerable groups. I would really, again, I'd be interested to hear the Minister's thoughts. And the one point I wanted to point out outside of sport is I'm working with a constituent of mine on allegations of historical childhood rape in schools. I know this is an extremely sensitive subject, but it is part of a petition at the moment, and it's now gone into court. Now, I'm never going to comment on particularly on a court case, but the teacher in question at that time was just moved to another area, and the PVG check didn't follow them. So again, this bill perhaps gives us an opportunity to close what I think is a fairly major loophole within the law. Presiding Officer, has already been outlined that the Disclosure Scotland Bill attempts to simplify a complex disclosure system in Scotland, which again is very welcome. I think the reservations that have been said today, and I have as well, is that it's attempted to do so in a very complex manner. I think evidence from the Law Society and Children's Scotland and Recruit with Convention concur with this concern. I won't repeat these as they've already been highlighted. In conclusion, Deputy Presiding Officer, we on these benches will support the bill at stage 1, but in doing so recognise there is a fairly hefty amount of work required to make it fit for purpose at subsequent stages. I would urge the Scottish Government not to lose sight of the objective, which must be to ensure that the application for a PVG certificate is user-friendly, doesn't deter those who wish to volunteer, all the while maintaining protection for those in our society who are most at risk. And I'm more than willing to work with the Government on this, should they see fit. Deputy Presiding Officer.
Alec Neil, followed by Mary Fee.
Thank you, Deputy Presiding Officer. Can I very much welcome this bill, and can I say there are very few bills we've passed in this Parliament over the last 20 years or so which will impact as many people in Scotland as this bill will. As Ian Gray pointed out, there are now 1.2 million people registered with Disclosure Scotland. And as Brian Whittle has just shown, that's actually can be a very good experience or not such a good experience, but it does impact people's ability to serve their community in the way in which they wish. But it's not just the 1.2 million who are registered with Disclosure Scotland. If you think of all the people those 1.2 million are actually responsible for example, if you look at the teachers and the number of children who they are responsible for, if you look at the registered social workers and social care workers and health workers and the number of people they're responsible for, as Brian Whittle said, if you look at all the sports organisations in Scotland, the number of people registered for them and the other third sector and voluntary organisations and the number of people they're responsible for, by the time you add all that up, it's not 20% of the Scottish population, it's probably nearer double that figure, nearer between 35 and 40% of the Scottish population are impacted by this legislation. So this is a major piece of work, and it's extremely important that we get it right. And I'll give two issues I would like to raise with the Minister. The first one is, it was mentioned by Elizabeth Smith, that, and this also affects the Bureau and the committee itself. It is not the first time in this Parliament that where we have passed legislation too quickly, primary legislation, we have had to reintroduce corrective primary legislation because we didn't do a thorough enough job first time round. I think with such an important bill as this, such a complex bill as this, let us take our time to make sure we get it right. Now, my understanding from the convener of the committee, the timetable isn't just quite as tight as Elizabeth Smith said. But I say to the committee and to the Bureau, if this takes a wee bit longer to get it right, then let us take the time to do so, because we could adversely impact the lives not just of those registered, but also of those who are members of vulnerable groups in our society. And the other point I would make is this, and I say this as a member of the Audit Committee, because we deal with umpteen issues of IT systems that have gone wrong in the public sector. And if you add up over the last 20 years, the number of IT systems and the total cost of not getting it right, we're well into hundreds of millions of pounds. But more importantly, it can destroy the improvement that's intended from service delivery because of the time it takes to correct IT systems that have gone wrong or not been properly planned. So I would say to the Minister and to Disclosure Scotland, do whatever you can and everything you can to ensure that you get the IT system right. Brian Whittle's absolutely right. We want to make sure that you don't need to wait 6 weeks. for the process to be completed. You don't want to have to resubmit your application because the IT system is faulty. If we're really going to make these big steps, big improvements, then planning those improvements, making sure at the project management stage that we get it right, will save a lot of heartache, agony and money at a later stage. And I think that's extremely important. It would be a great tragedy if we pass this excellent bill, which still requires some amendment and further consideration, as I've said, but it would be a great tragedy if we pass this excellent piece of legislation and then it falls foul of these practical issues and the purpose of it and the scope of it and the intention of it is undermined accordingly. Better to take our time and get it right. Now, there are a number of very specific issues that I wanted to raise, and I repeat many of the things that have already been said. For example, what Rona said about simplification, that is extremely welcome. I particularly like the fact that those people who have moved on in life, who perhaps in their teens get into a bit of trouble, ended up getting a criminal record, but they're not bad people, these people should not go through the rest of their life being penalised, having opportunities to help others, having sometimes their potential or actual careers ruined because Disclosure Scotland is effectively casting up, because it's legally obliged to do so, casting up something that happened many years ago in very extenuating circumstances and which didn't involve particularly those cases which did not involve a very serious criminal offence. And I'm delighted that we are not going to make life so miserable for these people who've clearly moved on, want to help others, want to rectify their mistakes, want to serve the community. They should be allowed to do so. And I think those kind of progressive elements in the bill are very welcome indeed. Can I also say, and I think Rona referred to this as well, the Minister and the committee must listen to the representations made by outside bodies. I don't always agree with the Law Society of Scotland, but for example, in their submission, requesting further amendment to protect human rights, for example, and to deal with the list of offences, because there are some issues there that clearly need to be sorted at stage 3, I think we've got to take those seriously. But we've also got to look at any potential impacts on other aspects of the bill as new amendments are considered. And that must be seen in its totality. You know, you can't just look at the amendments and only look at the paragraphs that are being amended. In a bill of this complexity, they need to take a comprehensive view to look at the impact and potential unintended consequences in other provisions of the bill. But I do think these are important points being made, not just by the Law Society, but by a number of the other organisations who have made a submission. So I congratulate the government on this bill. I congratulate the committee on the excellent work it's done. I think there's a bit more work to be done, but hopefully by the time we get to stage 3, we have a bill that we can all be proud of. Thank you.
Can I remind members always to use colleagues' full names when they're referring to them in their contributions? I know we're all pals, but it's useful for the official report and broadcasting. I now call Mary Fee to be followed by Jenny Gilruth.
Thank you, Presiding Officer. And can I begin by thanking the Education and Skills Committee for its work throughout this inquiry, which has given us a very informative Stage 1 report. And I'd also like to express my gratitude to all of the individuals and organisations who provided such valuable input to the committee's inquiry, and prior to that to the Scottish Government's consultation on its proposed changes to the disclosure scheme. And as my colleague Ian Gray said in his opening contribution, we welcome the ambitions behind the bill and will be voting in favour of it this evening at decision time. And the Stage 1 report offers a wide range of recommendations to strengthen the bill, and I note from the Scottish Government's response to the report that there will be changes brought forward at Stage 2 to further strengthen the bill. And these recommendations and the Government's commitment to act on some of them are welcome to ensure that the bill continues to meet the ambitions behind its introduction. And simplifying the disclosure regime is necessary in order to reduce the complexities that many people face when navigating the system in order to perform both paid and voluntary work with children and often vulnerable adults with quite complex needs. And reducing the levels of disclosure from 4 to 2 and the products offered from 10 to 4 received significant support from respondents to the consultation, thus strengthening the arguments for simplifying this scheme. And Community Justice Scotland rightly pointed out that simplification of this landscape is critical to ensure that people with convictions are afforded the opportunity to move on with their lives. And as someone who has debated in the Chamber on many occasions for better rehabilitation for prisoners, this is one area that could support that rehabilitation to society and would allow those with offending behaviour to live a constructive and rewarding life and put their past events and behaviours behind them. And protecting the most vulnerable in our society is a fundamental duty of any government. And I believe that the bill continues to meet that duty whilst making it simpler for people to engage with the disclosure scheme. And I welcome the provision to introduce digital applications. And this would make it easier for the applicant and would reduce the administration to both Disclosure Scotland and to employers submitting applications. And it is right that a non-digital system remains in place for those without access to a computer or the necessary skills to apply online. And I also welcome the comment from the criminal justice voluntary sector, who pointed out in evidence that people in the justice system are more likely to have speech, language and communication needs, lower educational attainment and higher rates of learning difficulties. And it's therefore very important that regardless of need, people have the right support and access to information on disclosure. And, Presiding Officer, although I am supportive of the principles behind the bill, I have one area of concern, and that surrounds the use of other relevant information. And although assurances have been provided that a Scottish Quality Assurance Framework would be developed in relation to Police Scotland sharing other relevant information, I do remain concerned about the sharing of information of behaviours that an applicant may have shown during their childhood. And Alistair Hogg from the Scottish Children's Reporter Administration said, "The concept of other relevant information is understandable, but disclosure of it, particularly in relation to behaviour that has happened during childhood or adolescence, needs a very high threshold." And I fully agree with Mr Hogg in the point that he made, that's where the reservations lie around the sharing of other relevant information, especially for people who have come through the hearing system. And the Education Committee pointed out its concern that the potential for disclosure of other relevant information held by the police undermines one policy objective of the bill, which is to allow individuals to move on from past offending behaviour. And I read with careful consideration the response from the Minister with regards to the concerns around other relevant information and take on board the points that have been raised. However, I will observe with interest how this issue develops through stage 3 and into stage 2 and into stage 3. And finally, Presiding Officer, I also support ending the lifetime membership of the PVG scheme. And there was widespread support for this part of the bill as it reduces some of the administration and monitoring of those no longer required to be in the scheme. And in evidence, the Church of Scotland raised concerns about how the transition from lifetime membership to 5-year renewal membership would be managed. And as this legislation progresses, I would look to the Government to clearly set out how this transition will be managed. And my only reservation, however, is the penalising of those who fall foul of the new term limits. And I would not wish to see anyone criminalised for failing to reapply. Nor do I wish to see those on low incomes who have to pay to reapply every 5 years be financially burdened. And I note that the current cost of application is around £60. So my final point today, Presiding Officer, would be to ask the Minister to proceed with caution when setting the fee in future, and to think of those low-paid workers or volunteers who pay for their membership themselves. This scheme cannot be a tax on those performing valuable caring and support roles, or a barrier to them continuing in that role. Thank you.
Thank you. I call Jenny Gilruth to be followed by Maurice Corrie. Jenny Gilruth.
Thank you, Presiding Officer. Can I start by thanking the Education and Skills Committee clerks, to the Bill team and all of the witnesses who helped provide evidence ahead of the publication of our Stage 1 report. The Disclosure Scotland Bill's focus, as we have heard today, is on reforming how individuals' past behaviour is recorded by the state. Furthermore, it makes provisions for a number of changes to the Protecting Vulnerable Witnesses, or PVG scheme, of which, as Ian Gray advised the Chamber earlier, there are over 1 million members in Scotland. And as Rona Mackay outlined previously, the policy memorandum notes the provisions of this bill will deliver a range of positive and proportionate reforms to the disclosure regime in Scotland, whilst also strengthening the barring service to maintain the Scottish Government's ability to protect the most vulnerable in society. As has been said, Part 1 of the bill considers the disclosure of unspent criminal convictions and other relevant information, or ORI. And Part 2 makes amendments to the Protection of Vulnerable Groups Scotland Act 2007, the PVG Act. Other relevant information, or ORI, is that information which currently can only be disclosed in an enhanced disclosure or a full PVG scheme record check. This might include allegations held on local police records regarding an applicant's behaviour, for example, as Mary Fee outlined. Today's bill proposes to reform the provision of other relevant information. This will end the current process of disclosures being issued to employers before the applicant has had an opportunity to challenge the disclosure of ORI. Furthermore, the bill will end the automatic disclosure of convictions accrued while aged between 12 and 17 years old. Indeed, one of the key policy objectives of the bill, as Liz Smith pointed out earlier, is the acknowledgement of adolescence as a unique phase of life. As CELSIS noted in their submission, the disclosure of childhood information disproportionately affects young people and adults with care experience, who are more likely to have had contact with the police and to have been involved in formal processes which lead to recording of behaviour. Howard Leeds Scotland agreed, and they noted that people who are looked after or care experienced often have arrested development and are less likely to move on in life compared to someone who is perhaps engaged in an isolated offence at the age of 13. As such, the committee highlighted our concerns with the potential of the disclosure of other relevant information to stop individuals from moving on due to that past offending behaviour. This was felt to be of particular concern with regard to childhood offending and for those who were care experienced, and I was glad to hear the Minister reference this specific point in her contribution at the start of the debate. The Government's response notes that Police Scotland's evidence to the committee, who asserted that all information is rigorously considered before any disclosure of other relevant information is made. The response also highlights provisions in the bill for any applicant to submit representations prior to the release of ORI. Part 2 of the bill makes amendments to the PVG Scotland Act 2007, and specifically in relation to 76 of the bill, which amends the meaning of protected adult. Scottish Women's Aid raised some concerns in their written submission to the committee. SWA highlighted the proposal to redefine the meaning of protected adult, which will list vulnerability through disability or illness. And in their written submission, Scottish Women's Aid say that focusing on disability or illness will create a loophole, as this definition would not automatically cover women experiencing domestic abuse. They state that this change in the definition in section 76 is too limited and could create a specific issue for women experiencing domestic abuse who are accessing refuge accommodation. As such, Scottish Women's Aid requested that section 76 is amended to include what they describe as the full spectrum of services within which regulated roles in respect of protected adults would exist. I raised this point with the Minister in our evidence session, and I know that government officials have met with Scottish Women's Aid to discuss their concerns, so I was absolutely delighted to hear the Minister confirm in her speech that she will bring forward amendments on this matter at stage 2. One of the key aims of the bill is to simplify and to modernise the disclosure system for users and organisations, and the committee heard evidence that for some people the application process itself can provide further barriers to entering the labour market. And as Robert Dorian from Who Cares Scotland explained in evidence, the stereotypical person engaging in the disclosure process may have had 1 or 2 moves, but what about the person who has had 14 or 16? The onus is on them to know about those changes, to know where they are at what time, and to know about the support mechanism that is in place. And Robert Dorian was keen to point to the obligations that Disclosure Scotland has towards those with a care experience background, particularly with regard to the role of corporate parents in ending what he described as secondary discriminatory practices against care experienced people. And I note from the Government's response that Disclosure Scotland are going to mount a major communications exercise in advance of any of the reforms which we are discussing today. And I would hope that that campaign would look effectively to consider the needs of care experienced young people in particular, who might be reluctant to engage in the disclosure process itself through no fault of their own. The committee was also cognisant that non-digital means of applying to the disclosure process should be maintained, and as such we welcomed in the policy memorandum the confirmation that whilst a move to digital services is going to happen, it's going to be part of the reforms. They will not fully replace a non-digital way of applying as well. Presiding Officer, today's Stage 1 report is the start is the start of a process of simplifying and modernising the disclosure system. It is focused on balancing public protection with the right to move on from past offences, something which the committee heard was particularly pertinent for young people and for those who have care experience and who may have ended up in the past labelled for life. And in closing, I would like to again pay thanks to those who provided the committee with evidence ahead of today's debate, and I look forward to the next stage of our deliberations with a focus of delivering a fairer disclosure system for the most vulnerable in mind. Thank you.
Thank you very much. And I call Maurice Corrie to be followed by Gail Ross. Maurice Corrie.
Thank you, Presiding Officer. I welcome this first stage of the Disclosure of Scotland Bill and thank the Education Committee and the clerks for their efforts in producing this Stage 1 report. I also must declare I am a holder of a PVG certificate, and I also declare that I have a daughter working at Disclosure Scotland. The disclosure system in Scotland is undoubtedly complex and presents many areas which call for caution, clarification and improvement. The Disclosure Bill seeks to address these issues, and so in principle I support it at this stage. The system delivered by Disclosure Scotland is designed to offer a layer of protection to vulnerable groups in society, covering children as well as protected adults. And this ensures that the recruitment process will only allow suitable individuals to work with these groups. This bill needs to take a balanced approach. In seeking to protect vulnerable groups in our communities, it must also respect every individual's right to privacy, recognising the right point in which rehabilitated individuals are entitled to move on from a past offence. I appreciate the bill's aim to simplify the disclosure system. By making it more user-friendly, I hope that this will remove long-standing complexities within the system to make it easier to navigate through. In streamlining the current 4 disclosure products, basic, standard, enhanced and PVG, to 2 levels, which will cover basic disclosure and more serious offences respectively, I believe this bill will offer users and organisations much-needed simplified options. Connected with this is the digitalisation of the disclosure system, which is most welcome. This will allow users to make applications and view their disclosures online while making the process quicker overall. However, I do agree that a paper-based system should be continued alongside this service, being mindful of those who may not be computer literate or based in areas without reliable internet connections. And as the Shadow Veterans Affairs spokesman, I'm keen to highlight the submission of the Royal Blind and Scottish War Blinded, which welcomed the idea of PVG membership cards as a sound alternative option to the digital process and sought greater clarification on how this might be implemented. I know I'm not alone in my concern of legislative overlap and discrepancy regarding how updated disclosure processes will work in practice. Indeed, the Centre of Youth and Criminal Justice, Social Work Scotland and Community Justice Scotland were just some of the organisations to come forward and highlight this issue to the committee. We have the Management of Offenders and the Age of Criminal Responsibility Acts, which, when linked together with this bill, present inconsistencies regarding how childhood convictions should be treated, and whether under a self-disclosure or state disclosure regime. There is further confusion over whether it is the date of offence or date of conviction, as mentioned already, that the Disclosure Bill will take into consideration. And whilst I recognise that these discrepancies are being actively considered, as the Minister has already confirmed today, I do hope that a logical solution will be found before Stage 2, and I fully agree with Alex Neil's very valid points made here this afternoon. In terms of the PVG scheme, the move from lifetime membership to renewable 5-year membership will lessen the number of individuals monitored when it is no longer required, ensuring their right to privacy. At the same time, this will keep the system up to date and more manageable. Indeed, as it stands, the PVG scheme has over 1.2 million members, as already been mentioned, and not all these individuals are still carrying out regulated work. However, the committee evidence spoke of a need for clarity surrounding the transition period before this proposal is implemented. And this will allow organisations to adhere to this change in a more feasible timeframe and with greater understanding. And moreover, for those situations where an individual has failed to renew their membership by mistake, I join others in suggesting that further consideration is given, moving away from penalties or short sentences that are inconsistent with the sentiment behind the bill and the current legislation. And further clarity and guidance are needed before the bill reaches stage 2 in changing the concept of regulated work to regulated roles, as again mentioned already, under the revised PVG scheme. This change will describe the work undertaken, which is to offer greater accuracy. And yet, despite this, many smaller businesses and organisations have uncertainty of what may or may not be included under this description. In the same thread, there may be a scope to expand on how the bill defines vulnerable groups. For instance, its definition of a protected adult arguably centres on protecting those with health-related needs, inadvertently missing out other vulnerabilities that may need protection, such as old age and homelessness. This is worthwhile to explore, and I look forward to seeing if this could be improved in further considerations by the Minister and the Committee. And to conclude, Presiding Officer, there are clearly areas in this bill which need further detail to make it a workable improvement on the complicated systems we currently have. And whilst I support its key principles, further consideration is needed to address these issues, particularly with such an important piece of legislation. Thank you.
Thank you very much. And I call Gail Ross before we move to closing speeches. Gail Ross.
Thank you, Presiding Officer. And I would also like to add my thanks to the clerks, my fellow committee members and everyone that has given evidence to the Education and Skills Committee, both in writing and in person. It has been thorough and at times complicated, but such is the depth and importance of the legislation we are dealing with. And this legislation helps to protect some of the most vulnerable people and groups in our communities. And as Alec Neil pointed out, it is imperative that we get it right first time. The bill was introduced in the Scottish Parliament by the Cabinet Secretary last June and aims to take what we have seen to be an overcomplicated system of disclosure and to simplify it. And during the passage of the Protection of Vulnerable Groups Scotland Act 2009, the government did say it would review the PVG scheme, and as this has been in place since 2011, and the Parliament has recently passed other related pieces of legislation, such as the Management of Offenders Act and the Age of Criminal Responsibility Act, the decision was made to review and update the whole disclosure scheme. Now, as we have heard, and this is what happens when you go last, everybody has said everything before you, there are various changes that are being made, one being to reform the current suite of disclosure products. Currently, there are 4 types of disclosure checks: basic, standard, enhanced and PVG. And the proposal is to replace these with level 1 disclosure, which would be the equivalent of basic, and level 2 disclosure, which would replace everything else. And the government consultation responses show that there is significant support for this reduction. Other feedback was that the complexity of the system lay not only in the suite of products available, but in a lack of understanding of the underpinning legislation and difficulty in navigating the system. The bill also makes changes to enable the provision to apply and receive disclosures digitally. It is hoped that this will also simplify the system, but it is worth noting that there will still be a paper-based system for those that require it, and this is also in line with respondents to the consultation that express support for the move to digital with the provision of a non-digital alternative. And the committee also recommended full engagement with those organisations that couldn't access a digital platform. And I am sure that the Audit Committee will give the IT system proportionate and thorough scrutiny when the time comes. One of the other major changes will be to end the lifetime membership of the scheme and replace it with a 5-year renewable membership. Disclosure Scotland told the committee that of the 1.2 million people that are currently on the scheme, as much as 20% are no longer doing regulated work, and they consider it important that the scheme membership accurately represents the amount of people in Scotland that do undertake regulated roles. However, one of the committee's concerns about this is that there could be a proposed penalty of a short custodial sentence, and it recommends that the Scottish Government look again at this to see if this is proportionate. And I also agree with my colleague Mary Fee, who asked about the people on low incomes, and I'd be interested to hear from the Minister if there would be any help with funding for these individuals. Now, Presiding Officer, as I said previously, this legislation does not stand alone. I'm sure most of my colleagues do as well. I do love a package deal when it comes to legislation. It's our duty as legislators to ensure that these laws that we make fit together seamlessly. And a number of our witnesses noticed what they saw as discrepancies between this legislation and the ones I mentioned previously, namely the Management of Offenders Act and the Age of Criminal Responsibility Act. Organisations such as the Centre for Youth and Criminal Justice, Social Work Scotland and Community Justice Scotland all expressed concern. And their concerns included state disclosure and self-disclosure, the date of the offence versus the date of conviction, and how the new acts align in general with the new disclosure system. And I know that the Scottish Government has already confirmed that there will be amendments coming forward at stage 2 to deal with any discrepancies. And I also welcome the Minister's earlier explanation to Liz Smith. I felt that was extremely helpful in addressing some of these concerns. The committee also recommended that any future legislation, such as the incorporation of the UNCRC, will also work well together, and I'm glad to see that the Minister in the Government's written response has confirmed that that will be the case. There was also broad support for the move to reform how offences committed by young people between the ages of 12 and 17 are disclosed, and how the new bill will bring about the end of automatic disclosure. And I just want to share a quote from Community Justice Scotland. This, at a stroke, would reduce the likelihood that people would experience discrimination based on events that happened when they were a child, which have no reflection on their current or future potential to work or study as fully rehabilitated adults. In conclusion, Presiding Officer, as with any legislation that comes before us at stage 1, this bill will have a few amendments, I have no doubt, at stage 2, but the underlying aim to simplify the disclosure scheme is an entirely sensible one, or to use Ross Greer's word, it is sound. As a committee, we support the general principles of this bill, and I urge my fellow members in the Chamber to do the same. Thank you.
Thank you very much. And we move to closing speeches. I call on Daniel Johnson to wind up for the Labour Party.
Thank you, Presiding Officer. And I'd like to begin, as others have, by first of all thanking the clerks. This has been a thorough debate. Indeed, I think our stage 1 evidence was thorough too. And that is only possible because of the hard and diligent work that our clerks undertake. But I'd also like to thank my fellow committee members, and indeed very much in the manner that Gail Ross has just outlined. I believe that we have done our jobs thoroughly, both in public and indeed, I think some of the discussions we've had in private session, and I think it reflects what has also been reflected in today's debate, is that sense of that shared responsibility that we all have to get this right. To get this right, because there is no greater collective duty that we have than to protect the well-being and welfare of our children and vulnerable people, but also, just in terms of the raw numbers, as a number of speakers have pointed out, that the PVG scheme is something that so many people, indeed 1 in 5 people, as Ian Gray pointed out, undertake. And so for these reasons, it's important. And I think it says much that there was so much overlap between the opening speakers in this debate. And I think we all share the Minister's sentiment that we should make this bold reform. But in doing so, that we must do a number of things. First of all, we must balance that responsibility with the rights of the individual to move on from any past crimes or indeed issues that they have had in their lives. But that must be balanced with the need for protection, and that we must have reform based on those principles. And those reforms must provide simplification of the system, predictability of the system. But I think there's one other issue which has been touched on by a number of speakers, I think particularly by Ross Greer. There is also an issue in terms of the perception of how this system will operate and how it technically will operate. And I think that is why the two-stage test is so critically important. Now, I'm going to talk about this with a degree of trepidation, because I don't think I've ever spoken in a debate where so many people have predicted what I'm going to be talking about as on this particular topic. But it is an issue that is of concern for me. Now, the two-stage test in itself, I think, is sensible. Indeed, there is case law which establishes what it is and how it should operate at a high level. But if we are wanting predictability in this, having clarity is important. And Clan Child Law, in their evidence, were very clear that they found it difficult to be able to provide advice to people who maybe have information disclosed under this proposed legislation on the basis of the two tests. Now, if legal bodies and legal organisations such as Clan Child Law cannot provide that, then the understandability of this law and how it will be operated, I think, is certainly in question. Now, what I'd like to do is provide a counterfactual, and just before I do, I'd like to, in part, provide a small apology to the Minister. When she was giving evidence, I gave her a rather unfair test of being able to explain what the difference might be between relevant and ought. And I think that the key test that is to be able to explain a situation where information would be relevant, but ought not to be disclosed, i.e. it passes one hurdle, but not the other. And the issue is this: I think relevance is easy to understand. A situation or information which directly relates to the job that's being undertaken by the individual. But the ought test, I think, is more complicated. Ought, to my mind, always relies on another underlying value in order to test it. Now, I apologise if I'm sounding like a philosophy graduate, but I am. But I think this is incredibly important. And let me just say this, because if you look at actually the things which should inform that in the case law, it's things such as time and context of the instance in question. And the issue is this, is if we're talking about proportionality, if we're talking about risk, one person's proportionality will not be another person's, which is why I think we have to elaborate further. And I accept what the Minister is saying, that much of this will be laid out in guidance. But the reality is, because these tests are so pivotal, it is very difficult to scrutinise this legislation without seeing this guidance if those values aren't further explained on the face of the bill. Which is why I welcome the Minister's willingness to look at amendments at stage 2 in terms of providing those tests. And I would urge her to examine the suggestion of the Law Society that we provide high-level principles, albeit amendable through secondary legislation and also backed up by statutory guidance. That way we can scrutinise and we can understand how this law will operate. But importantly, the people who are potentially subject to it will also be able to understand it. I'd also just like to mention a few other issues which have been raised by other members. I think the issue around other relevant information mentioned by both Mary Fee and Rona Mackay and others is critically important. And in a sense, the glib analysis of this, if you look at the conditions on the bill in terms of disclosure of conviction, they are lengthy. In terms of other relevant information in Section 18, it is very short. But the reality is in terms of the volume of instance that could be disclosed, the other relevant information may well be much greater in terms of that volume than conviction information. Likewise, it may counterintuitively provide the very insight into those convictions that wouldn't be disclosed because of the age of the individual, but because of the other relevant information, it might be disclosed. I think we really need to examine this further and make sure that there are no such contradictions or loopholes. Likewise, I think Ross Greer's examination of under-16s and the impact of volunteering, I think, highlights the point I made at the beginning. There is a critical importance to understand between the operation of this in terms of its technical operation and the perception. And I think that's what's at the very heart of that particular issue. We don't want to put under-16s off from volunteering because of both the contribution that they can make, but also the value to them as individuals. I'd finally like to touch on the issues raised with other legislation. And indeed, this has been interesting for me as a committee member examining this bill, having spent some time on the Justice Committee, especially through the passage of the Management of Offenders Bill through the Justice Committee and ultimately the Act. Because not just because of the interactions between those two bills, and I think a number of members have identified the issues there, but also I think in terms of how it fits with other legislation and indeed how the government plans for legislation. But just on the points in terms of those overlaps, and again I appreciate that the Minister has stated that she will bring forward guidance, but that is critical, because again it comes down to confusion. Time and time again, when it comes to disclosure, the critical point that is made by so many is when you have confusion, you have over-disclosure, and that can impact and exacerbate the stigma faced by those individuals. But I think perhaps the other point is this, is that I would urge the government to think carefully when planning legislation, to think about the interactions, because we've got 3 bills that have passed through this place in quick succession, and yet we have this question about how those interactions will work and whether there are unintended consequences from these different bills, different acts which have passed within a matter of months of each other. And I would therefore like to end with a reflection on Alec Neil's points. Let's take our time. If we need to take further evidence at stage 2 to contemplate both those interactions and whether or not we have adequate information from the government, let's do that, because let's get this right, because as so many people have pointed out, this impacts the welfare and well-being of our children and impacts so many people in Scotland that undertake invaluable volunteering work. Thank you very much.
Thank you very much. And I call on Alison Harris to wind up for the Conservative Party.
Thank you, Presiding Officer, and I'll start by declaring that I also hold a PVG certificate. I'm pleased to be closing for the Scottish Conservatives in this Stage 1 debate today. As my colleague Liz Smith said in her opening remarks, we support the principles of the Disclosure Scotland Bill. We all agree that protecting the most vulnerable people in our society is crucial, and if we can make the administering of that more efficient, then we should. Yep. The Education and Skills Committee Stage 1 report expressed that the committee is very concerned with certain aspects of the bill. As Claire Adamson and Ross Greer and other members have mentioned in their speeches, one of these concerns was that the impact of the bill could have on volunteers who are under the age of 16. The contribution young people make through volunteering in any capacity cannot be overstated. Committee evidence revealed many concerns about the minimum age requirement of 16, combined with PVG membership being mandatory for regulated roles. Indeed, one organisation stated that the bill will likely be interpreted to mean younger people under 16 cannot undertake regulated roles. Whilst I appreciate that the Scottish Government acknowledges this concern, it is an area that will require further clarity as the bill progresses. Another issue highlighted at committee was how the proposal to move away from lifetime PVG memberships to a 5-year renewal period would be implemented. There needs to be a proper transition so that organisations do not end up with a huge budget commitment at the same time every 5 years due to current PVG members renewing on the same day. I know the Minister suggested a couple of options for addressing this issue in her response to the committee report, and I look forward to debating these options at Stage 2. I now turn to the Bill's promise to digitalise the disclosure system. The end goal is to increase efficiency, and this would be a welcome outcome. But I think there are grave lessons to be learned from the recent move to the new IT system known as PASS, or Protecting and Safeguarding Scotland. In the Chamber in June last year, I raised concerns with the Minister on the robustness of any IT system tied to the Disclosure Bill. In response, the Minister said, and I quote, "We are confident that the system is at an appropriate stage and will be completed in time for the delivery of the new services." Disclosure Scotland has a target to complete 90% disclosure checks within 14 days. But in September last year, the percentage of PVG checks completed within that target fell to 47.8%, and in October it fell again to just 12.5%. I heard about the huge delays to disclosure checks firsthand from childcare providers who were unable to put staff in place to work due to PVG checks taking twice as long as they should. At the end of October, I wrote to the Minister for Children and Young People, and in her response, she told me that these delays were partly due to seasonal pressures causing an increase to workloads, and partly due to bedding in of the new digital PASS system, which went live in September 2019. The recent Audit Scotland report on Disclosure Scotland also highlighted a reduction in their performance in November as well. The report in full has made for some very interesting reading. The report included a summary of the transition to the PASS system. In this, it showed that Disclosure Scotland in June 2015, their proposal to the Scottish Government to take the digital contract out of BT's hands was rejected for its high cost, a figure of £77.2 million over the transition period 2015-16 to 2022-23. According to Audit Scotland's report, 4 months later, Disclosure Scotland returned with a second proposal, stating a projected cost of £34.1 million. The Scottish Government accepted this revised offer. However, in the years since, there have been several revisions to the budget forecast until in November 2019, the costs were higher than the original figure of £77.2 million that was actually rejected in the first instance by the SNP government. The bottom line is that the PASS system is over budget. It was not ready to be fully rolled out in September, and as I previously stated, lessons have to be learned from this, especially in the light of digital updates being required with the passing of this disclosure bill. And at this stage, I would like to acknowledge the very pertinent comments made by Alec Neil in regard to IT systems. The final issue I will address today is the bill's coherence with other legislation passed in this Scottish Parliament. As other members have mentioned, several recent parliamentary acts have legislated on similar issues to this bill. This includes the Age of Criminal Responsibility Act 2019 and the Management of Offenders Act 2019. These very recent acts may need to be amended to correct the contradictions and discrepancies that have arisen because of the introduction of this disclosure bill. I agree with the Education Committee's conclusion about the importance of ensuring no more discrepancies arise when incorporating the United Nations Conventions on the Rights of the Child, or the UNCRC, into Scots law. The Minister's response to the Stage 1 report stated that the disclosure bill was designed with the principles of the UNCRC in mind, but did not confirm that changes to this bill would not be required when incorporating UNCRC into Scots law. Instead of a piecemeal approach to legislation, it's important to ensure that these pieces of legislation work well together, as Beatrice Wishart mentioned in her speech. To conclude, I would like to reiterate that we will support the disclosure bill at Stage 1, but fully believe that amendments and clarifications are required at Stage 2 on the issues that have been raised in the Chamber today. More issues than I've been able to cover, such as other relevant information, which I know Mary Fee mentioned and Daniel Johnson mentioned, and I appreciate the Minister also tried to clarify in her opening speech. Well, we need further clarification and discussion on these. Several MSPs discussed the new list of offences and regulated roles, and I think these are areas requiring close consideration going forward. For the continued protection of vulnerable groups, which everyone in this chamber acknowledges is essential, we need this legislation to be right. Thank you.
Thank you very much. And I call on the Minister Marie Todd to conclude our debate. Minister.
Thank you, Presiding Officer. I thank the members around the chamber for their contributions today. I am very pleased that there is support across the chamber for the general principles of the bill. The debate has been constructive, and I want to make absolutely clear my commitment to keep working together in this complex area. I've listened very carefully to the debate, and I will consider the issues that have been raised today and in the committee's report as we proceed. The Disclosure Bill enhances existing protections and it closes potential safeguarding gaps, creating a more robust disclosure system. The bill refocuses the PVG scheme onto those who possess power or influence over children and protected adults. It was evident from the Health and Sport Committee's consideration of child protection in sport, particularly when they were discussing the role of football scouts, that many of those involved at a senior level did not appreciate the power imbalance that exists between clubs and children. I want to reiterate my appreciation to the stakeholders who've engaged with us on the change to regulated roles and continue to provide feedback on this issue. It's absolutely vital to ensure that the legislation provides sufficient coverage to protect vulnerable groups. My absolute priority is the continued ability of the disclosure system to support the protection of the most vulnerable in society. People who, through their past conduct, are unsuitable to undertake such roles must still be prevented from doing so. However, it is important that children are treated as children. The Children's Hearing System and the focus on early and effective intervention provides a proportionate and flexible response to harmful or criminal behaviour by children. The disclosure system must be able to take a proportionate approach to including information from this unique period of life, and the bill, I believe, allows us to do so. It is important that we also have a disclosure system which gives all applicants greater control over their information. Some people have past conduct which makes them unsuitable for roles with vulnerable groups or valuable assets. However, this must not be used to prevent all of those with convictions from accessing employment that we know helps to reduce reoffending. Doing so further denies our communities the value of their skills and experience. For most people with convictions, the passage of time and living a law-abiding life provides a basis for them to access work and to make a great contribution to society. I recognise that this can be difficult for employers, and I encourage those who want to learn more about employing people with convictions to access the free Scotland Works for You training, which is offered by Disclosure Scotland. This initiative helps employers to understand how to make risk assessments on conviction and rehabilitation. Legislation gives us the levers to reform disclosure, but in order for individuals to be truly able to access their rights, comprehensive and accessible guidance about the disclosure system must be available, and the Scottish Government is committed to delivering this. Guidance will be provided in different formats for a range of audiences, and it will be developed in conjunction with users and stakeholders. This must include children and young people, as well as the organisations who advocate for them. We already have interest from a range of groups who want to support Disclosure Scotland to develop the guidance. I'm going to try and pick up on a number of issues that were picked up, highlighted during the debate by multiple members. But I want to take the opportunity to reassure you that if I don't manage to respond to the particular issues raised, my door is always open, and I'm more than willing to meet with members and to facilitate access to officials if there is anything that you wish further clarity on. On the issue of coherence, I would like to refer you to the written response that was given to the committee, which highlighted that the government progressed all three pieces of legislation: the age of criminal responsibility, the management of offenders, and the Disclosure Scotland Bill by adopting a joined-up policy model, sharing ideas, information, team members, and ensuring policy coherence, uniting the three. Each act or bill has had its own parliamentary journey, and the provisions of each are absolutely consistent with each other in broad policy terms. Certainly.
Liz Smith.
Full to the Minister, and I think she's right. I think the Scottish Government has gone into some considerable detail on that, and hopefully with legal advisors, obviously, on some of the definitions. I think the challenge that we face is to try to get that across to some of the stakeholders, because it is complex language, yet they're the practitioners that have to operate the system, and I just wonder if the Minister could reflect on that point.
Minister.
Certainly, and our work with stakeholders, I would hope you would acknowledge, has been thorough and committed, and we will continue the work with stakeholders to make sure that we respond to the concerns that they are raising during the course of the progress of the bill. What I would like to say is that it's inevitable, when this legislation was introduced last year, when this particular bill was introduced last year, the other two pieces of legislation were not yet enacted, and it is inevitable that there will be procedural and technical inconsistencies between them which require to be remedied. And we always foresaw that, and we are committed to bringing everything fully into line and to do that by second stage. I would also like to take the opportunity to reassure the committee that the bill was drafted with regard to UNCRC principles and the Children and Young People in Scotland Act. I think the other issue which was raised frequently was the decision-making and the two-part test. And as I set out in my opening remarks, I accept the calls for including more detail in the bill on decision-making around the relevance and ought to be included tests. I'm carefully considering the recommendations on how best to include these principles without compromising the flexibility which is necessary to give full consideration to each set of circumstances. I think it's helpful to be clear about which type of information we're talking about to which the two-stage test applies. The two-part test of whether something is relevant to the purpose of disclosure and ought to be included in the disclosure applies to three separate categories of information: ORI, childhood conviction information, and removable convictions. And although the wording's the same, these tests will be applied in different contexts depending on the information in question and also in the stage in the review process. Maintaining the same wording is absolutely crucial, certainly.
Daniel Johnson.
Again, I'm very grateful to the Minister for giving way. I wonder if she'd reflect whether or not that the fact that the test would apply differently in those different contexts, which I accept, actually underlines the need for greater clarification and indeed perhaps to put it on the face of the bill.
Minister.
And certainly, as I set out in my opening remarks, I'm very, I'll bring forward a Stage 2 amendment to address the committee's recommendation of including the principles on the face of the bill. We've begun early engagement with stakeholders to develop the guidance to be used by decision makers, and that the crux of this issue is making the outcome of any assessment or review process more foreseeable and accessible to disclosure applicants. And user-friendly guidance is essential, not just for applicants, but for those who may support them. And a number of members around the Chamber talked about just how challenging and complex this bill is. But I have confidence that this Parliament can rise to meet those challenges, and our close work with stakeholders will enable us to communicate the legislation once we have completed it. In terms of the Disclosure Scotland's digital transformation, it is paving the way for the work to take forward this bill. Many of the innovative changes in the bill could not have been implemented using the previous IT system. The PASS system is already dealing with all of Disclosure Scotland's current business, and we'll work with our customers to ensure that there are solutions for the delivery of the bill which meet everyone's needs. Lessons have been learnt through the implementation of the original PVG scheme in 2011 and the current digital transformation at Disclosure Scotland. The digital functions required to implement the bill will be developed on an agile basis, as set out in the financial memorandum accompanying the bill. And Disclosure Scotland will begin the discovery phase for bill implementation in the coming months. With regard to the Auditor General Section 22 report, Disclosure Scotland will consider the report's findings and take appropriate action to address the points which have been raised. In fact, they've already made a number of changes to improve the clarity of governance, including the creation of a change delivery advisory panel to provide critical challenge and support and assurance.
Can I just take this moment to ask members to keep the conversations to a minimum? Thank you.
Thank you. The introduction of a minimum age on disclosure is not unique. The Disclosure and Barring Service introduced a lower limit of 16 years old back in 2012, and Access Northern Ireland did the same in 2015. So the legislation that we are introducing is now coming into line with what occurs in the rest of the UK. I'm conscious of the concern that an unintended consequence of the measure would be a reduction in volunteering opportunities for children. Disclosure Scotland will work with Volunteer Scotland Disclosure Services and across Scottish Government to ensure that organisations offering volunteering to under-16s understand the changes and continue to offer opportunities to children. Certainly.
Ross Greer.
Thank you. I'm very grateful for the Minister taking that intervention and for the points that she's made. Would she be able to confirm whether or not the Government will agree to the review that the Education Committee have asked for into the impact of this bill on the participation of under-16s in volunteering?
Minister.
Certainly, as I said, we're more than happy to work with bodies that represent volunteers in Scotland to see if that there is a change in the level of volunteering. Like you, I understand just how significant children and young people's volunteering is. In fact, children and young people volunteer at about twice the rate of adults, so not only is it important for children, it is also important for Scotland that we ensure that they are able to continue to volunteer and do not introduce any barriers to them volunteering. In terms of the penalties for the offence under the bill, I just want to reassure people that when we introduce a mandatory scheme, it can only be effective if it's supported by a criminal offence. But these penalties are consistent with the provisions in the existing legislation. And although the legislation currently includes the penalty of imprisonment, since the legislation was introduced, there have been no sentencing to prison for people who have not navigated the system appropriately. All of these issues are important ones, and I want to thank members for raising them throughout the debate. While at this stage we focus on the general principles, I want to again reassure the Chamber that the discussion with the stakeholders and the bill's proposals and implementation and planning will continue as we move forward. Again, I want to offer to meet members from across the Parliament. I'm open to discussing the detail of the bill and taking the time that is needed to work through the complexities. I believe that the committee's approval of the principles and the general tone of today's debate are indicative of a shared view across this chamber that we do need to reform the disclosure system. Together, we can ensure that it continues to protect the most vulnerable in our society while also being rights-respecting and proportionate, and I look forward to our next steps together.
Thank you very much. That concludes our Stage 1 debate on the Disclosure Scotland Bill. The next item is consideration of motion 1992 on a financial resolution for the Disclosure Scotland Bill. Could I invite Derek Mackay to move this motion?
Moved.
Thank you very much. The next item is consideration of motion 20456 in the name of Fergus Ewing on the Direct Payments to Farmers Legislative Continuity 2020 Bill. Could I invite Fergus Ewing to move this motion?
Formally moved.
Thank you very much. So we're going to put these questions at decision time. First question is that motion 20452 in the name of Marie Todd on Stage 1 of the Disclosure Scotland Bill be agreed. Are we all agreed? Yes. We are agreed. The next question is that motion 1992 in the name of Derek Mackay on a financial resolution for the Disclosure Scotland Bill be agreed. Are we all agreed? Yes. We are agreed. Thank you. And our final question is that motion 20456 in the name of Fergus Ewing on the Direct Payments to Farmers Legislative Continuity 2020 Bill be agreed. Are we all agreed? Yes. We are agreed, and that concludes decision time. Oh, point of order, Alistair Allen.
I thank you, Presiding Officer, and my apologies. Time has prevented me from having the opportunity to give you advance notice of my point of order. The Presiding Officer, you will be aware that Parliament has a duty to represent the people of Scotland, and at risk of saying something people already know, both the people in Parliament of Scotland have voted to indicate their preference to remain within the EU, despite which fact Scotland will of course be taken out of the EU against its will in a few days' time. I note, Presiding Officer, your announcement today that the corporate body has taken a decision to lower the European Union flag at Holyrood. Arithmetic would suggest that Conservative, Liberal, Democrat and Labour MSPs, representatives, that is, on the corporate body voted for this. My question, Presiding Officer, is that given that the corporate body is, as you know, accountable to Parliament, can you advise what means exist for members, or indeed the Chamber as a whole, to challenge any decision of the corporate body, or indeed to take such a decision into their own hands?
Can I thank Mr Allen for the point of order? Just for information, I would correct Mr Allen that the corporate body did discuss this at length and was very aware of the political sensitivities, of the feelings of members of this chamber and of Scotland generally. The reason that this decision is delegated to the corporate body is to make it a non-political decision. It's to make it as non-political. There is a huge amount of symbolism and politics in flag waving and flag flying, as you will know. The corporate body takes decisions in the interest of the Parliament, not in the interest of any party. It is a neutral and trusted institution, and the members of the corporate body were very aware of the need to do so and not to take a political decision on this matter. It is a matter for the corporate body and not one for other parts of the Parliament. I hope that answers the member's point. I hope that answers the member's point. I would thank you for the point of order, and I close this meeting.